Than these compliance letters. These are people who are receiving letters saying you shouldn't have gotten money or you got too much money, pay us back. And as you might imagine, that causes a lot of consternation. I've had to get a couple of them corrected where they were wrong. Can you tell me is there a protocol, is there a standard letter and is there a protocol for the recovery letters? And how do y'all determine if you're going to send a compliance letter, you're going to send a recovery letter? Because I can tell you that a recovery letter out of the blue causes a lot of heartburn.
We have been sending recovery letters for years now for files that were determined to have been overfunded, whether they got insurance payment after the fact or any other reason for that. We've determined that they were overfunded. Those recovery letters have been going out. That is separate from our compliance letters that just went out. Those are people we've already established have what we call a negative variance with the program and owe money back. The compliance letters, by and large, are people that, based on our field surveys and electricity information, water information, all those things, a good 85 to 93% of those people are back in their homes, and we just got to get paperwork from them. The people that are getting those recovery letters, on the other hand, are people that we have established that they owe money back to the program. Same process. They need to get in touch with us and walk through their file with us and show us what we've got wrong, or let us show them what all we have and complete their file so that we can finish the process with them.
And I completely understand this is a two-way process. The state set up programs to help people. The people need to be responsive and show that they're using the money properly and everything else. But my question or my concern is a recovery letter shows up out of the blue. There wasn't a phone call. There wasn't an initial letter which says, hey, our records indicate we may have overpaid you. Would you contact us? All of a sudden, the instances I've been contacted on, the letter basically says, you have been overpaid, you owe us this money back, you better pay us by X date or we're coming after you. What is the protocol, or how do you determine someone 3 years later has been overpaid and you send a recovery letter? Are you just going back and re-reviewing hard copies of their files, determining that there was a mistake made and sending out a letter? How is this happening? And what process? Also, I want to know what interaction is there with the homeowner to know that there's a question about their file before all of a sudden they just get a recovery letter?
Can y'all speak to the process of recovery?
Yeah, certainly. The grant recovery letter.
Why don't you identify yourself for us?
Laura Robertson,
Okay.
Director of the Homeowner Program. In terms of the letter itself, the grant recovery letter that we've been sending out is kind of a soft letter. It basically says, please contact the program so that we can go walk you through your file to determine whether or not an overpayment has been made. To my knowledge, we haven't changed that language for the past couple of years, so it's not a demand letter. Those letters don't actually go out until they get to the Attorney General's attorney's office.
Well, maybe the letters that I've seen have come from outside lawyers that have been hired by, I assume it was OCD.
The Attorney General.
The attorneys, so that doesn't come through your office, that comes through the Attorney General's office?
It does. They get the names from us and the contact information. We're telling them who to send letters to, but they are in effect acting as our collection.
The constituents that I talked to who got recovery letters from outside lawyers never received any contact before that. This letter that you indicated come from y'all, they've never indicated they received that. All of a sudden they just receive a recovery letter from an outside lawyer.
That's not possible the way our computer system is set up. We have to generate 3 grant recovery letters. We're required to do that. So the first 2 letters would come directly from our office. State staff send those letters out. And then once we don't get any response or an adequate response, then they go to the Attorney General's office. It's the way it's processed through our system. So a homeowner would have to get 2 letters in order to get that 3rd letter. Okay.
Well, or they should get 2 letters. I can tell you in a couple instances my constituents told me they didn't get them, but your process is set up where they should get advance notice before they get a letter from an outside lawyer?
Yes, they should get 2 letters in advance of that letter.
Thank you, Mr. Chairman.
Representative Brossett.
Well, thank you, Mr. Chairman. Representative Abramson hit it on the head. Some of my constituents have been getting letters from outside counsel that's, I guess, given the status of Special Assistant Attorney General. So maybe, I think there needs to be more communication between General Caldwell's office and OCD, because if you're getting a letter for recoupment being the only letter from the State Attorney General, that, of course, doesn't sit well with many homeowners who back in their homes.
As Ms. Robertson said, they don't send a letter until we tell them to. I don't think that we've got a lack of communication about who should be getting the recovery letters from those firms.
Mm-hmm.
Well, Pat, why don't we do this? I mean, I know we're not going to resolve this evening. Can we?
We don't have a mortgage on the property, no.
I mean, if it's an
There is a
can you put a
covenant.
lien on it?
I'm sorry?
Can you put a lien on it?
We don't have a lien on it. We've got a covenant with them that's attached to that deed.
Right,
And
but can you put a lien on it in the event that there was clear abuse of the money, they didn't do anything, there was no contract or fraud?
our effective control is through the covenant that's attached to the deed.
Well, Pat, you might want to look to your right. Your folks are saying
All right.
yes.
Oh, thank you.
So let them answer. Let them answer. Introduce yourself
Yes,
again.
Jeff Haley with the Road Home Program. Yeah, the answer is yes. But that would be done through the Attorney General's office.
Oh,
They can
right.
put a judgment on it or something
Okay.
through the recovery process. So
Okay.
that would be the appropriate steps that they would do next. If the homeowner does not agree to pay the funds back or go on a payment plan, they could issue a lien then on that
And
property.
can they garnish wages?
There are those steps they can do, yes. They have all the legal steps that could normally be
At their
followed on the
disposal?
debt.
Okay.
At
All
their
right.
disposal.
Thank you.
Anybody else on the panel? Yes, ma'am. Are you Miss Barnes? Okay, Nicole Barnes, come on up and just introduce yourself and tell us who you represent. Mr. Cohn, you're here on the. All right, Stanley Cohn.
Good evening, Mr. Chairman, members of the committee. My name is Stanley Kahn. I'm resident 900 Turquoise Street, New Orleans, Louisiana. I was a Katrina disaster victim. I was an option 1 applicant to the Road Home Program. I received a $110,200 compensation grant, approximately, and a $30,000 elevation grant. I'm not here tonight to ask anybody for any more money. That's not why I'm here. I'm here tonight for the most important reason that I've been before this committee over the past 4 or 5 years, however long it's been in existence. And as I stand here tonight, I feel like the character in the Tom Clancy novel, Clear and Present Danger, and I'm talking about Acting Deputy Director Jack Ryan. For those of you who know of the novel, know of the movie that was, Jack Ryan was played by Harrison Ford, he stood before a congressional body toward the end of the novel and end of the movie to testify about what he discovered, and that was covert activity within the executive branch of higher echelon people, and he did not think that was correct. And I'm here today in that same vein, based on evidence that I have discovered and have not had an opportunity to present to this board or this committee before tonight. It's very serious. These people here in front of us, in front of you and in front of me, took an oath to the disaster victims of Louisiana to treat them fairly, to treat them civilly, to treat them ethically. And I disclosed evidence during the course of my own personal investigation when I requested documents and spoke to a number of people, both at the lower level and the upper level, that appeared to me that the truth was not followed. And that's why I'm here tonight, to confront these people, because this is the only opportunity that people like me have to confront them when we uncover what appears to be wrongdoing. We ask them questions and they refuse to answer. So we have to come here to air it out, because otherwise we'll never get an answer. I got one of those letters, Representative Abramson, one of those grant recovery letters, said I owed him almost $61,000 and to pay him back. I raised hell. Within 1 week of my receipt of that letter, the grant recovery was withdrawn. And 2 or 3 days later, I got a letter that said I was 100% compliant. Okay? I was able to defend myself. Most people who are Road Home Option 1 recipients, grantees, are not. That's another reason why I'm here today. Because if I don't do this, no one else will. Now, what are the facts that I uncovered? Well, part of the reason that they said I was overpaid $61,000 was based on their policy, their rules. It changed. I don't know how many versions they had. I know it was over 16. And it all depended upon when your particular road home case was analyzed as to how much you got. If you were analyzed earlier, maybe you got a little bit more than you did if you were analyzed later, or vice versa. It worked both ways. It changed. But they didn't go back each and every time to say, all right, all those that we've done before, should they get a little bit more? Should they get a little bit less? Couldn't do it. Otherwise, we'd still be here today, with the road home. Whereas today, most of the grantees have received their grants by now. What I'm here today to talk about is honesty. Honesty. Because in my particular case, there was a fact that had to go into the equation, and that was whether or not my disaster flat roof covering the patio and carport was attached or detached. It took me 2.5 years before they would ever even accept to review my evidence. And that's a fact. 2.5 years. I was pleading with them, coming before this board, coming before this committee, excuse me. Will you please accept my evidence? No. Well, finally in October of last year, almost a year ago, they did. And they sent a memo to their contract employees at HGI. And that's the first document that I've given you. It was sent, it appears here, it says here by, I believe, Mr. Jeff Haley to Owen Hawes. Owen works at HGI. And he was given the assignment of reviewing information to determine whether or not my rear flat roof was attached or not. Now, the significance of that is the fact that based on their analysis, not mine, their analysis, if that flat roof was attached, I was actually underpaid almost $40,000 on my compensation grant. If it was detached, then they could make the claim, well, I was still overpaid, but it was ICF error. All right?
Mr. Khan, I know you have a lot to say. We're here to, but
I'll speed it along. I'll speed it up.
More concise.
Bottom line is this. They had their attorney contact me, and we spoke in detail. I told them, hey, you could walk from the trussed roof to the flat roof with no air gap. All right. Throw that out of the way. Because what Owen Hawes had was what I had also presented, and that was satellite pictometry. Pictures don't lie. And those photographs proved, without a doubt, and this is objective, credible pictometry, both pre-Katrina that they had, post-Katrina that I had, showing the trees on top of my roof, that this flat roof was attached, that you could walk from the trussed roof of the disaster roof straight onto the other without an air gap. All right. So what's the significance of that? Well, that meant, according to Owen Hawes, that they should add another $150,000 to my compensable damages. When you do that, then there's the $40,000. But then they'd have to come and tell me, oh, Mr. Khan, we made a mistake, and come before this body after they had told you how many countless times, oh, We didn't make an error. ICF did. Oh, I remember one night Pat said, oh, I looked into it. Nothing was there. He whispered just like that. I was flabbergasted because I knew back then what was in this memo. Now, what happened with this memo, it got put in my road home file, I think, without their knowledge, but we'll never know unless we ask Owen Hawes. Owen knew that it was attached. Owen knew I should be given $150,000 extra dollars. He told Jeff Haley. It's in here. He quoted Jeff Haley. You ready for me to put it in there? Jeff responded, quote, not yet, close quote. Why do you think Owen put it in quotes? I think because he knew what was going on. And he didn't want to be implicated when they got disclosed. He says here, his last comment was, Jeff Haley informed me that the decision made today by Lara was that the flat-roofed area will not be added to the CAD or total area calculation. If you turn to the next letter, which is about a month later after this, November 13 insert in this memo, if you look down at the bottom, they write, based on your own description, meaning my description of the carport as a detached structure. They claimed it was detached, yet the pictures in their own HGI, contract employee says that it's attached. Significant factual error. And so I want this committee, I ask members of this committee to ask individually, Jeff Haley, Laura Robertson, and Pat Forbes, how did they, or why did they determine that my flat roof was detached when it was clearly shown on objective, credible pictometry that it was not? And I'm not here to ask for more money. That's not why I'm here. I'm here for one reason, to teach them that honesty is the best policy. That's it. That's the only reason why I'm here. Thank you.
Well,
Yes.
before that, I mean, I guess I should ask them first. Do you all have a copy of this?
They've got it. I provided it to them in the past.
Okay. Is there a reason why when Mr. Hawes, I don't know how you pronounce it, said if he wanted you to put the flat roof in, you said not yet? Is there a reason why? Mr. Haley?
We were continuing to analyze whether the roof is attached, or whether the garage is attached or detached. There are a lot of...
I mean, once the HGI guy said it was attached.
We're
paying these guys to go out and do the work, right?
That's right. And previously, an ACI person had said it wasn't. It has been a very difficult case to... the pictometry is not as accurate as being
I got
displayed.
it. So you're saying another HGI person said something different?
Correct.
There's a document that says that someplace?
I requested everything. They didn't.
Wait.
It was in his original CAD that way, which is his compensation allowance document when they first went out there. Mr. Kahn's home wasn't there when they went out there, so they had to go by what the homeowner said.
I understand. I got it. He was clear about that. They used the pictures before and after.
And there's documents as well that have said that Mr. Kahn stated that it wasn't attached.
I'm sorry, what was that?
Well, no, that's the kind of talking. What he said is that the documents that reflect that you said it was not attached. But we're not going to resolve this here tonight. But so the key thing is, Mr. Kahn, I want to thank you for bringing this to our attention. There have been many people who have come to these meetings to say that the determinations made by ICF, HGI, Shaw, whatever kind of contractors or staff people from OCD, they made an incorrect decision on a lot of grants over the years. So, I mean, I don't think that really surprises anybody up here, quite frankly, but I do think it is important that this document says one thing. I guess I'll have to figure out if there's another document that says something different. But there have been many people who've come before this committee, I guess, in individual phone calls to our offices over the years that talked about, I don't know if the right word is incompetence, whatever it is, about people, contracts who've worked in this program, and have made people jump through all kinds of hoops many times, present the same information, all kinds of stuff. So I think we're aware that there have been problems with this program. I don't think anybody's surprised about it.
My comments tonight are not based on incompetency. My comments tonight are based on what appears to be an intentional They haven't explained themselves. What appears to be an intentional act of dishonesty.
I understand.
I just want an explanation.
Well, he just
Why?
Mr. Connie, he just said, and once again, I'm not seeing no file. He said that documents in your file where somebody else said it wasn't attached. He said there's documents where you say it wasn't attached. I don't know. I haven't seen this. I can't answer that.
I will make a request to Christy Nichols tomorrow to produce the documents that Mr. Jeff Haley just referred. How do I describe those, Jeff, in my public record?
You have to make the comments to us. I mean, so,
Mr. Chairman, could you ask Mr. Haley how I should describe them so I'll be sure to get the copy?
Well, you can probably go back and look at this on the they replay this all the time. But what he said to me just now and to this committee is that another HGI employee said it was not attached, and he said there were documents in your file where you said it was not attached before. That's what he said, and I may not have it word for word, but that's what he said to us tonight. But you could welcome to go listen at it and make the request. And if you need some assistance, please copy me on the request, and we'll try to help get it for you. But that's what he said. We're not going to resolve it.
Right.
But you've been really persistent, many times coming, not just speaking for yourself, but for many other people in the program, and you've done a really good job doing that. But we're really not going to be able to resolve this issue tonight.
Right. All I want is an honest answer.
I understand. And as a citizen, you're entitled to it. They owe it to us to do that when they sign these cards, when they talk about these jobs, they swear that they're telling the truth. They owe the truth to all of us. But I wish I could tell you we resolve it. We're not going to resolve it tonight.
Unless they want to tell us the truth.
Senator Murray, can I have just make one statement?
Introduce yourself again.
Connie Udo, St. Paul's Homecoming Center. When they talked earlier about making people pay back now money because they were overpaid, I just want to make a statement that is horrible to do to people who have built back, and because they have made so many mistakes themselves, and they're going to make people go through that stress again, jump through hoops to prove to them that they were not overpaid. People have faced tripled insurance costs, not even flood insurance, rising insurance costs since we've come back. More people are in the hole because of their rebuild. I haven't seen anybody driving a Jaguar from their rebuild, okay? And I just want to state to you all, I think that should not be happening. They should not be putting people who have come back. You say you want us to come back, but you dared us to try. And we did it in spite of you. But now to go to people with these horrible letters, like he was saying you're going to have to pay money back, and Stan saying you're going to have to pay money back, that's just criminal. It's blackmail. So I just want to make that statement.
Let me just say
I wish you all would act on that.